And now joining us this morning is DOJ Spokesperson Atty. Polo Martinez. Good morning, Attorney. Thanks for joining us.
Hi, Pauline. Good morning. Good morning to the viewers. Thanks for having me.
All right. Well, the DOJ, the Department of Justice, has been at the center of several major developments this week, from the ongoing flood control probes. I understand, Attorney, that 3 of the 5 cases with the DOJ are already submitted for resolution. What are the next steps there, Attorney?
So for cases being submitted for resolution, that means that all the evidence have been submitted at this point. That includes the complaint by the NBI, of course, and the counter affidavits by the respondents. So as long as they do not intend to submit any additional supplemental counter affidavit, for example, then being submitted for resolution means that all there is to do is to assess the evidence submitted and determine whether the evidence as it stands meets the quantum of proof under the rules, that being prima facie evidence with reasonable certainty of conviction. So we can expect that to be done in the next couple of weeks, hopefully by mid-December, and we could then see if whether the case will then proceed to trial.
Right now, Attorney, what kind of evidence is the panel currently scrutinizing? Are we talking about documents? Will this also include what was found from the site inspections, testimonies, and even technical reports?
Okay, so with respect to the particular evidence now, Pauline, I'm afraid that that's something I cannot disclose as to not preempt the judgment or the resolution by the panel of prosecutors. But as to the type of evidence, it's that includes not just affidavits, but also the evidence specific to the sites in question. So for the 3 out of 5 cases, we're looking at Sims Construction in Bulacan. Testimony as well as documentary evidence.
And so for these 3 cases, Attorney Polo, just to clarify for the public, who exactly are the respondents? I know this involves engineers from the DPWH 1st District Engineering Office and Sims Construction, but are we talking about Henry Alcantara, Bryce Hernandez, JP Mendoza?
Yeah, of course, yes. So all those names that you mentioned are included as respondents, DPWH officials. And we're also looking into the culpability of certain high-ranking congressmen and senators, high-ranking politicians in this case. But again, as to not preempt and preclude the judgment by the panel of prosecutors, these are items that we cannot yet disclose, but then the public could expect that the resolution will indicate whether or not these people or these officials are in fact being implicated as well.
So based on your investigation, Attorney, you already found ties to higher officials, possibly congressmen?
Well, there is no definitive link yet until the resolution has been submitted or has been rendered. But it's safe to say that links are being found or are being seen in the evidence submitted that could possibly lead to it. So I think there's been, I guess what that means is there's development, there's progress into the public clamor, for seeing whether or not we could really look into the culpability of these high-ranking officials.
And what will the DOJ do, Attorney, when those ties are established? Possibly, will they be given to the Ombudsman for the Sandigan Bayan to decide on?
Yeah, that's correct, Paulina. Thanks for mentioning that. So these high-ranking officials being under the jurisdiction of the Sandigan Bayan, then if they are found to be, if their participation is found in these cases, then these cases will necessarily have to be referred to the Sandigan Bayan for its appropriate action in a way of by means of referral before we could then proceed to file it with the Sandigan Bayan.
Okay, Attorney, so these cases, I understand, involve, here are some of the possible charges: malversation through falsification, there's perjury, there's also violations of the Anti-Graft and Corrupt Practices Act. But among those allegations, which would you say is the strongest or has the strongest supporting evidence or would lead to an actual conviction of these respondents?
Okay, so again, Pauline, I'm afraid I'm gonna have to withhold some information with respect to that kasi itong mga bagay na to, it's up to the panel of prosecutors to decide on. And if we speak too early on it, similar to the subject visa rule, with this in courts, we cannot say anything which will be subject to any interpretation or which the public could misconstrue So until these evidence are aptly and appropriately assessed by the panel of prosecutors themselves, we're gonna have to step back a bit and let them do the work and let them be the ones to say whether or not the evidence merits or could stand the rigors of trial. What I could say though is these malversation and violations of the Anti-Graft and Corrupt Practices Act are grave enough offenses that if ever it does proceed to trial or if ever the information is thus filed in court, then they will be met with a heavy penalty in case of conviction.
Okay, I understand you can't really talk about evidence yet as of now, but maybe you can walk us, attorney, through the elements needed in order to establish violations of the Anti-Graft Act.
Okay, so the Anti-Graft Act, there are actually many items and provisions under that law that point to many different crimes. So when someone says that there is a violation of the Anti-Graft and Corrupt Practices Act or RA 3019, it doesn't necessarily mean just one crime because there are very many sections in it. But I think the common provisions, common elements rather related among the provisions is when one individual holding a position in government acquires unwarranted benefits to himself to the prejudice of government. So we'll have to be able to look at the elements and see whether or not practices were done which were detrimental to the public, and whether they indeed received benefits from these practices. So it's those elements we're looking at. When we say prejudice, that's if funds are being diverted or taken from the coffers of government, then obviously there is prejudice to the government. In the case of ghost projects, if no project was implemented, yet funds were diverted or stolen from the coffers of government, then that's indicative of the prejudice we're looking at.
Well, as we mentioned, 3 cases are already up for resolution. So what happens now to the 2 remaining cases that are still under preliminary investigation? What exactly is the DOJ waiting for? Is it supplemental submissions of affidavits? I understand some of the respondents also asked for an extension. Tama ba, attorney?
Tama, yeah. So tama, no. The extension of time was asked last November 24. So for all those who actually asked for extensions of time, they were only granted until November 28. So dapat at this point nakapagsubmit na sila, no? For those for those cases that are still undergoing PI or preliminary investigation, that's only because some of the respondents, or rather some respondents were added to the case because of one reason or another. So yun yung mga and so because they were added late in the process, then they necessarily received the complaint late, so they were given time to submit their counter affidavits. But all those who were able to receive their complaint timely, were able to timely the complaint, then they were only given until November 28. That's 4 days from the actual deadline of the filing of counter affidavits, which was November 24. So mabilis na nga yun because normally in the ordinary course of things, respondents would be given say like 2 to 3 weeks to be able to draft their counter affidavits. But because we know that time is of the essence in this case, we gave them a shorter period of time to do so. So lahat ng nabigyan ng time to submit or whose motions for extension were granted were only given that short period of time.
Attorney, can you disclose sino-sino po itong mga humingi ng extension?
Marami yan, Pauline. So and it's different per case. So remember that these 5 cases, even though na may mga common correspondence siya, they're not all the same, and the number is also not the same. So sa 5 na yan, one case, for example, would have 6 respondents, and then another case would have as many as 20. So it depends kasi on the particular type of facts and circumstances that's particular to every case. But like I said earlier, these 5 cases, and we remember that these 5 cases were the same cases referred back to us by the Ombudsman, in which we were deputized. The DOJ was deputized to conduct preliminary investigation. So iba-iba yan, but they all relate to the Sims construction in Bulacan. And we're also looking at more charges.
Attorney, I wanted to get an update on the applications before the Witness Protection Program who are still currently under evaluation to become state witnesses.
So what we know so far is that there are two individuals who are provisionally admitted to the program, in which they are granted provisional benefits under the WPP, or the Witness Protection Benefit Security Act, which is the law. That is Engineer Henry Alcantara and Yusek Bernardo. And as we know, recent development is that Engineer Henry Alcantara had already surrendered or returned 110 million of the funds that he had admitted to have taken from the coffers of government as part of the terms and conditions of his memorandum of agreement with the DOJ or the WPP. So ito na yung sinasabi nating restitution, no, as part of the conditions.
Per attorney, is that more likely that they will become state witnesses because they are complying already with that requirement of restitution?
No. So whether or not it's likely is uncertain at this point, because we have to understand that the restitution is only one of many conditions under the memorandum of agreement. So unless they do comply sa mga ibang tungkulin nila dun sa MOA or the conditions set out, then it's too early to say whether or not they will be admitted talaga as state witnesses. No, but they are covered witnesses. I think it's important to make that distinction. Not just because you're provisionally covered by the MOA or by the terms of the WPP benefits, doesn't necessarily mean that you will be ultimately admitted as a state witness at the end of it all. So it's not that. And even if you are admitted as state witness, one thing we want to make clear is wala tayong blanket immunity. No, any immunity that will be granted to these individuals who will comply with restitution are only immune insofar as the amount that they return is concerned. So, kunwari, let's say you return the amount, but then you also have pending charges of tax evasion filed by the BIR, then you are not immune from those suits because those pertain to taxes you owe the government and not necessarily just the amount that you took from the treasury.
Okay, so Alcantara and Bernardo are now provisionally admitted to the WPP. What benefits do that entail? What's given to them as covered witnesses?
So it's numerous benefits, a number of benefits there. I think the most important, and I think what the public should take notice of, is the protection lang. That means protection not just like security protection, but also physical protection of their family members as well, who may be subject to threats. And currently, they also pending suits cannot be filed against them again in relation to the amount that they just returned. But also we have to take note that the amount that Henry Alcantara, the amount that he returned, is only it's only a partial amount as of now. The 110 is not the total amount yet, and we're still determining just how much he's actually supposed to return, no, and whether or not he can still get those still.
Well, Attorney, I understand also that the ICI recently held a technical working group meeting with other agencies. Kasama na po ang DOJ, also with the BOC, BIR, DPWH, among others. Can you tell us exactly what role the DOJ is playing there? And when it comes to asset recovery as well, how aggressive is the DOJ acting on that?
Well, one thing we have to take note is asset recovery is not the primary task. It doesn't fall under the mandate of the DOJ insofar as investigation is concerned. Ang pag-asset recovery lang na ginagawa ng DOJ is in relation to the Witness Protection Program, wherein we could stipulate restitution as one of the elements, or one of the conditions rather, in the memorandum of agreement. So I think asset recovery falls under the jurisdiction of the AMLAC, the Anti-Money Laundering Council. And any freeze order they may file correspondingly with the appropriate, the Court of Appeals. Based on the evidence that they have currently. I think, as I've mentioned before, it's important to make distinctions between the jurisdictions and mandate of the ICI, the Ombudsman, and the DOJ so that the people don't get frustrated, no, when something when let's say words like asset recovery or phrases like that are brought up. um, we first ask, ano ba ang trabaho ng DOJ with respect to this particular goal? No, okay, then we know that it's only in relation to the restitution, which they could stipulate as a provision in the MOA. Other than that, AMLAC being the more uh, having a more technical mandate, would be more in charge of being able to further this particular goal with the means and capacity and the resources that they have.
Okay, attorney. So let's talk about timelines. How soon can the public expect updates on the pending arrest warrants? I mean, I'm sure all our government agencies know that that people are getting impatient, right? Public trust is at an all-time low. So when can we expect arrest warrants or even possibly mga makukulong? Tama po ba na may makukulong na po by Christmas?
So we're ano dyan, malapit na kami sa goal na yan. Since that's the timeline we're working with. That's I think that's one thing people have to remember. Also, in comparison kasi sa timeline that's provided under the rules, we actually are given a lot more time under the rules to be able to resolve these cases. In fact, under the rules, sinasabi na 60 days, but because we understand the public clamor and the time is of the essence, we are doing everything we can to expedite these cases so that by mid-December, we could then file the case in court, and pag-file namin ang kaso in court, the information filed in court could then compel the judge to issue the corresponding warrant of arrest. And the warrant of arrest will then be the first step into acquiring jurisdiction over these persons, and then we could then proceed to trial and see if conviction is warranted under the evidence submitted. So,
Well, speaking
doing everything we can, no, aggressively, in fact.
Well, speaking of arrest warrants, there's already one out for former Congressman Zaldy Co, and yet his Philippine passport remains active because the DFA says it has not received a court order just yet. I understand this is a matter with the courts, but explain to us, Attorney Polo, what does the court need to establish before canceling a passport, considering that the accused already has an arrest warrant?
So as long as the case is already filed in court and the charges are already in court, no, all that there has to be done is for the prosecution or the complainant to file the corresponding motion for cancellation of passport on the ground that one person is evading charges in the Philippines, to be able to cancel his passport. So as long as the court sees that at the time the information was filed, for instance, wala na sa bansa yung would-be pugante or would-be fugitive, then it would have sufficient grounds, more or less, to grant the motion for cancellation of passport. Again, but this is something up to the courts to decide. It's a case-to-case basis, and it depends on the particular facts and circumstances with respect to a certain case and with respect to a certain individual. Kasi an individual may have many different cases filed in court, but a motion to cancel passport may not necessarily be granted in all of them, some over others, depending kasi yan sa facts. But yes, so normally it's as simple as if you, at the time of the filing of the charges, had already left the Philippines, and then there is evidence sufficient to show that you did so because of fear of being prosecuted here, then that motion will more or less be granted now based on jurisprudence.
And yesterday, Attorney, the NBI already searched the condominium of former Congressman Zaldy Co to find any evidence of possible bid rigging and in connection with the flood control projects. Meron po bang coordination between the NBI and the DOJ on that?
So ano rin yan it goes into the mandate of specific agencies. That's primarily law enforcement's job to enforce the warrant. The DOJ's job with respect to any arrest implemented is only to be able to supervise the seizure of items if indeed some exist pursuant to, for example, a search warrant that is also implemented. So hintayin, the coordination will come in once the NBI does file once the NBI transfers the evidence to the proper prosecution panel or team in charge of the case.
And finally, for my last question, Attorney, you previously said that in the case of Congressman Zaldy Co, the DOJ is still gathering proper evidence, and but you're, quote, getting there. Now, at this stage, are you confident with what you have? Because on the other side, you have his legal counsel, Attorney Rondain, saying he's confident that there will be nothing to implicate his client, and the burden is on the prosecution to prove Congressman Co's guilt.
First, Ella, let's make it clear, no? Tama naman si Atty. Rondain and any respondent for that matter that the burden of proof will always be with the prosecution. Whether or not definitive na makapagsampa kami ng kaso, I'm afraid I cannot speak on behalf of the prosecutors in charge of these cases. But what I can say definitively is that we have more evidence now pursuant to our investigation to be able to proceed. In other words, there is development. So it's not as if that what we have now is the same as what we had a month ago or 2 months ago. There has been progress, and so our confidence has been building up. But again, before anything is rendered, before any resolution is rendered, it will be too early to speak, I'm afraid, no? But we're getting there, like I said.
All right. Well, thank you very much for joining us this morning and for giving us your insights. That was DOJ Spokesperson Atty. Polo Martinez.
Thank you.